Good afternoon, everyone. I am Neha, student of LLM final semester. I will discuss with you a case study on the case the Government of NCT of Delhi versus Union of India. So we will start with the introduction. The provision for legislature through Article 239 AA was added to the Constitution of India to uphold the spirit of federalism, where the people of Delhi ought to have a democratically elected government representing them at the local level as well. The reason behind Delhi not being granted full statehood instead can be assumed as Delhi, being the capital of India, needs to have extra control by the union government, as it is always in the global eye, directly representing India. This landmark constitutional case was the result of an appeal filed by the government of NCT of Delhi against the Delhi High Court judgment, which observed that the Lieutenant Governor exercised complete control over all matter relating to NCT of Delhi, National Capital Territory of Delhi. Essentially, the scope of powers of the Lieutenant Governor, hereinafter referred to as the LG, and Government of National Capital Territory of Delhi, are being looked at closely by the Supreme Court of India. Now we will discuss what was the background of this case. In 1991, the Constitution of India was amended to introduce Article 239 AA, granting special status to the National Capital Territory of Delhi. This provision established a unique governance framework with a legislative assembly and a council of ministers responsible for the administration of Delhi, and the control over police, land and public order was given to the central government. However, the extent of power and authority wielded by the elected government in Delhi has been a subject of contention and interpretation. In 2015, the Ministry of Home Affairs issued a notification in which it was mentioned that the Lieutenant Governor of NCTD shall exercise control to the extent delegated to him from time to time by the President over services in addition to public order, police and land. The LG may seek the views of the Chief Minister of National Capital Territory of Delhi at his discretion. Entry 41 of the list 2 of the second 7th schedule, that is state list of the Constitution of India, mentions the term services in which state public services are covered, and this notification shunned the power of Government of National Capital Territory of Delhi over a subject of state list. The case raised critical question regarding the interpretation of constitutional provision, particularly Article 239 AA. The constitutional framework provides the foundation for the governance, structure and functioning of National Capital Territory of Delhi. So now we will discuss what was the main issue in the case. The major contention of both the parties in this case was who will have control over the services in the Union Territory of Delhi, whether the government of NCT of Delhi or the Lieutenant Governor of Delhi, who is acting on the behalf of the Union government, will have the power. So in this case, the Supreme Court of India held that in 2016, the first we will discuss some brief what was all happened behind. So in 2016, the High Court of Delhi gave a verdict in favor of the Union government. In an appeal to this, the Supreme Court of India, it was observed that the substantial question of law is involved here. It is about the interpretation of Article 239 AA, which deals with the special status of Delhi. In 2018, the Constitution bench held that the government NCT of Delhi is not like any other union territory, and executive and legislative power of National Capital Territory of Delhi extends to all subjects in the list 2 and 3 except those explicitly excluded. In 2019, a split verdict came, and still there was no proper judgment regarding the issue. But in the recent judgment given by the Supreme Court Constitutional Bench held that the Article 239 AA Clause 3 Subclause A confers legislative power to National Capital Territory of Delhi. However, the court stated that the Legislative Assembly of NCTD does not possess exclusive legislative powers over all the subjects listed in the state list. Its legislative authority is limited to a specific constitutional domain. If the interpretation of the phrase insofar as any such matter is applicable to union territories excludes more subjects than those already excluded by Article 239 AA Clause 3, it would undermine the purpose of granting a special status to National Capital Territory of Delhi. The court, in this case, the court drew a distinction between the control of services by the NCTD and Union in relation to the NCTD. It emphasized that Entry 41, which pertains to the NCTD, cannot be given to broadest interpretation. All entries in List 2, including Entry 41, must be interpreted in harmony with the limitations outlined in Article 239 AA Clause 3 Subclause A regarding the legislative and executive power of NCTD. This limitation excludes matters relating to public order, police and land. Therefore, the legislative and executive power of National Capital Territory of Delhi concerning Entry 41 does not encompass services associated with public order, police and land. However, the National Capital Territory of Delhi retains authority over services like Indian Administrative Services or Joint Cadre Services, which are crucial for implementation of NCTD's policies and vision in terms of day-to-day administration of the region. If these services are excluded from the legislative and executive domain of National Capital Territory of Delhi, it would mean that the ministers and executives responsible for formulating policies within the territory of NCTD would not have control over the civil services officers who are responsible for implementing those executive decisions. The court also clarified that the Lieutenant Governor can exercise discretion in two specific categories of matters. Firstly, in the cases where the issue falls outside the legislative authority of the Legislative Assembly, the President has delegated powers and functions to the Lieutenant Governor concerning that matter. Secondly, in situations where the law requires the Lieutenant Governor to exercise his own discretion or when he is carrying out judicial or quasi-judicial functions. In these limited circumstances, the LG is empowered to exercise his own judgment and decision-making authority, but in other circumstances, the LG is bound to act on the aid and advice of the Council of Ministers while discharging the executive functions within a domain of the Government of National Capital Territory of Delhi. Thank you so much.